before we close, just with the time that we've got remaining, I'd just like to take a brief moment to ask our panelists what their key takeaways would be. And with that, I mean sort of out of everything that's been covered on this webcast, maybe one or 2 points that you feel are the most pertinent. Xiaozheng, do you want to go first in terms of what your key takeaways would be?
My presentation is more informative than analytical, so it's just useful, I think, to be aware of what's around us and technology advances, and then develop patenting strategies accordingly.
Mm-hmm. And Hendrik, yourself?
So as just pointed out at the end of my talk, I would definitely recommend to include experimental data for each important aspect or class of compounds, depending on the type of technology, of course. Mere verbal statements are really risky, and in that case, you might wish to rely on a plausible technical concept, which, however, may backfire on your case. So the drafting, there's a subtle, balance to be made between what you disclose in the application and what you need to rely on in the prior art. And typically that's very dangerous, in particular if the patent is challenged in post-grant opposition proceedings. This valuable patent could really easily be revoked. And that would be too bad, like in the first case where we had got the blockbuster patent, which was revoked for lack of data, in short at least.
And finally, Jens Victor, what would be your key takeaways?
Well, I think I mentioned one of them before, that's expect the unexpected. And I think when you draft your patent application, play the devil's advocate and look at your claims in the way you would normally draft them and say, what if I all of a sudden cannot have this type of claim in my patent? What would I do then to try to at least cover part of my invention? Because we can expect that things are going to change because of the developing case law, as has happened with plausibility in Europe. We didn't know that, 10, 15 years ago. That's an evolving landscape. The case law and other types of biotech inventions are also evolving. Who could have expected that you can't patent products isolated from nature in the United States? Nobody could have expected that. And in that case, you need to have other types of claims to cover your invention.